Think of your judges as politicians, but that's exactly what they are.
Politicians who must hit the campaign trail for support, often from the same lawyers who appear before them. Tonight,
investigator Bob Norman has the story of a Broward judge who, since her election, has used the bench to benefit her top campaign consultant financially. It may not look good, but is it legal? Here's Bob with a story you'll only see on Local 10.
Does Mona answer?
The courtroom of Broward County Judge Claudia Robinson bustles with defendants.
Once the charges would be dismissed, it would not be used against you criminally.
I just wanted to bounce this off of you.
And when I visited recently, Judge Robinson, who won her seat in a razor-thin upset at the polls, told me a little bit about her work.
My job is to make sure that I uphold the law, and I help and I represent the people of Broward County to the best of my abilities.
But now there are questions about whether Robinson followed the law in regard to the political consultant who managed her 2014 election. Attorney and longtime political operative Michael Ahern.
I had a significant role in the campaign.
Michael's a good friend of mine and he helped me out.
Court records show Robinson has also helped out Ahern. Out of 299 appointments she's given to attorneys to mediate her civil cases, 247 of them went to her campaign consultant, a whopping 83%, leading to tens of thousands of dollars in Ahern's pockets.
Favoritism. Is this favoritism towards your campaign manager?
Absolutely not.
250 out of 300 roughly?
Again, I'm not going to stipulate to that figure. Have I given him mediations, appointed mediations? Absolutely. Have I appointed mediations to a plethora of other mediators? Absolutely as well.
And that's not in payment for his work on your campaign?
No.
Not surprisingly, such an arrangement wouldn't be legal. Florida law makes it a third-degree felony for political candidates to promise appointments in exchange for campaign support.
It is against the law for a judge to give appointments based on a promise.
Oh, okay. I can appreciate that. There is absolutely no promise that was made to Mr. Ahern. There was no promises that I made to anybody as part of my campaign.
I don't know whether it was favoritism or not.
Ahern denied there was any prearranged deal.
And you never had any type of conversation with Judge Robinson about getting these types of recommendations / appointments?
Never.
They just happened?
Nope. They happened.
He said that because litigants can disregard the judge's order and choose another attorney to mediate, he doesn't believe the law applies in this case.
Just because my name is on 250 orders doesn't mean I did 250 mediations.
Ahern actually mediated about 180 of them, which at $250 an hour comes out to about $45,000 in business for the lawyer.
Did I help her get elected? Absolutely. Have I received this as some kind of compensation for that? Absolutely not.
Ahern said neither he nor Robinson knew what kind of cases she would be assigned during the campaign, making a quid pro quo impossible.
You can understand that this looks suspicious.
All I can say is that there was never a promise.
Without concrete evidence of a deal being struck between Robinson and Ahern, all those appointments would indeed appear to be legal under Florida law. The question, should they be? In the video report, I'm Bob Norman, Local 10 News.
Bob, thank you. And Bob tells us that Broward County has a long history of favoritism on the bench. It got so bad in the 90s that the power of appointing attorneys to criminal defense cases was taken out of the judge's hands in favor of a random so-called wheel system that assured fairness.